continue this all day. I also will add you to the case if you want to continue this. This needs to be dismissed today. Today.
Before we even get into the legal weeds, let's set the stage here, because this is not your average courtroom dispute. We're back in Judge Coleman's courtroom, and front and center is Javar Grayson, a familiar sovereign citizen figure who believes traffic laws, court jurisdiction, and basic legal procedure simply don't apply to him. This isn't his first rodeo, either. In fact, if you've seen him before, you already know how this tends to go: bold claims, shaky logic, and an unwavering belief that saying the right magic words can override decades of settled law. This time around, though, he's taken things a step further. Instead of just arguing with traffic court, he's suing the police officer who pulled him over, claiming sovereign status, lack of jurisdiction, and a supposed right to travel that he insists nullifies traffic enforcement altogether. And here's the twist. He's asking for a default judgment while simultaneously claiming the court itself has no authority over him. That contradiction alone sets up a legal train wreck that Judge Coleman is about to dismantle piece by piece.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you're here at this time.
Yes, Your Honor. Javar Grayson representing myself.
This is where things immediately start unraveling for Mr. Grayson. Notice what Judge Coleman zeroes in on right away. You don't get to reject a court's jurisdiction and then ask that same court for relief. That's not how law works, anywhere. Grayson is arguing that he's a Moorish American national, that traffic laws don't apply to him, and that the officer had no authority to stop him. Yet at the same time, he's filing paperwork requesting judgments and demanding action from the very system he claims is illegitimate. Courts deal in consistency, not vibes. If you believe a court has no power over you, then logically, you shouldn't be filing motions there at all. Judge Coleman isn't confused. He's pointing out a fatal flaw. Sovereign citizen arguments often rely on selectively accepting legal authority when it's convenient and rejecting it when it's not. Judges see this constantly, and it never ends well. This moment is critical because it exposes the core weakness of Grayson's entire case before it even gets off the ground.
Thank you, Mr. Grayson. Good morning to you as
Good morning.
well. All right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You're telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. Then why are you filing something in this court if you believe the court doesn't have jurisdiction? You filed
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, I'm not, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you
Yeah,
talking about?
yes, sir.
So,
And we
let me go
understand
to,
that.
all right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Now we shift from sovereign ideology to actual civil procedure, and this is where the law completely leaves Mr. Grayson behind. A default judgment is not a punishment for disagreeing with someone. It's not a shortcut. It only applies when a party fails to respond at all. And as the defense attorney calmly explains, the officer responded properly and on time with a motion to dismiss, which is a fully valid legal response under Michigan law. Judge Coleman takes extra time here to explain something most sovereign citizens either don't understand or pretend not to. A motion to dismiss is a response. It pauses the requirement to file an answer and challenges whether the case even belongs in court in the first place. There's no default. There's no procedural failure. Everything happened exactly as the rules require. This explanation is important because it shows the judge isn't rushing. He's laying out the law clearly, step by step. So there's no confusion about why this request is being denied.
Well, certainly, let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. Now, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this? What is this case about, Mr. Grayson, sir?
It's about a traffic. I guess is a some type of traffic ticket. It started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that.
Here's the moment where Judge Coleman asks the most important question of the entire hearing. What is this case actually about? And the answer, after all the paperwork, labels, and sovereign language, is simply a traffic stop. That's it. A routine stop that Mr. Grayson believes violated his so-called right to travel. This is where the illusion collapses. Civil court is not a workaround for traffic court. You cannot use a lawsuit to relitigate tickets you're already fighting elsewhere. That's called a collateral attack, and Michigan court rules explicitly prohibit it. Judge Coleman understands exactly what's happening here. This lawsuit isn't about damages, misconduct, or constitutional violations. It's retaliation. And courts are not vehicles for frustration or protest. They require legally recognized claims, supported by law, not ideology.
And I do understand the default judgment. What do you that you are saying, and what is pertaining to? We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right. Yes. Very briefly, there was nothing filed by plaintiff. And it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
This is the legal brick wall Mr. Grayson never gets past: governmental immunity. Police officers performing their duties under the law are shielded from civil lawsuits unless there's a clear, specific violation, something far beyond "I don't consent" or "I'm sovereign." The defense attorney lays it out cleanly, and Judge Coleman clearly agrees. Traffic enforcement is not harassment. A lawful stop is not a civil rights violation by default. And claiming immunity doesn't vanish because someone rejects jurisdiction verbally. This is why these cases consistently fail. Sovereign arguments don't defeat immunity, don't override statutes, and don't substitute for actual legal claims. At this point, the outcome is already written. The only remaining question is how clearly the judge is going to spell it out.
All right, I got it. All right, that you failed to state of action upon which the court can grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter. Again, the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.